There is one bill collector in America that can reach into your bank account and take your money without ever filing a lawsuit, without a judge, and without a single court date. No hearing where you get to stand up and argue your side. They just send a letter, wait a little while, and then they can act. It's the IRS. Every other creditor you can think of, your credit card company, a hospital, a collection agency, has to drag you into court and win before they can touch a dime of your money. The IRS skips that whole step. That's what makes this different, and honestly, that's what makes it scary for a lot of people. But stick with me here, because the scary part is only half the story. There are hard limits on what they're allowed to take. There's a window of time that can stop the whole thing in its tracks. And if you're living on Social Security, your check is protected in ways most people have never been told. By the end of this video, you'll know exactly how this works and exactly what to do if it ever lands on your doorstep. If you like this kind of straight talk breakdown on money stuff that actually matters, go ahead and subscribe now. New videos come out every week, and they could genuinely save you a lot of money and a lot of stress down the road. So let's talk about what this power actually is, because once you understand it, it's a lot less terrifying. When somebody owes back taxes and just lets it sit there unresolved, the IRS can eventually issue what's called a levy. That's the official word for freezing money in your account and sending it to the government. And here's the part nobody talks about. The IRS isn't allowed to just decide one Tuesday morning to drain your account. The law requires them to warn you first, in writing, and that warning is the most important piece of paper you'll ever get from them. It's called a final notice of intent to levy, and it also spells out your right to a hearing. The moment that letter goes out, a clock starts ticking. By law, the IRS has to wait at least 30 days from that notice before they can take a single dollar. 30 days, that's your window, and almost every disaster story you've ever heard about someone's account getting frozen traces back to one thing, that window closed and nobody did anything with it. Here's where it gets interesting though. Inside those 30 days, you have the right to request something called a collection due process hearing. You file one simple form, and the second you file it, the law forces the IRS to pause everything until that hearing is resolved. Think about that. One piece of paper filled out and mailed back inside 30 days can put the entire levy on hold. Most people who get this letter have no idea that option even exists. Now, let's say the worst happens anyway, and a levy actually goes through. Even then, there's a second safety net most people don't know about. When the IRS sends that levy notice to your bank, the bank doesn't hand your money over the same afternoon. By law, they have to hold the frozen funds for 21 days before sending anything to the government. 21 more days on top of the 30 you already had to get this sorted out. So between the notice and the bank hold, you're looking at roughly 7 or 8 weeks of real, usable time. That's a lot longer than the fear in your stomach is probably telling you. By the way, if you're finding this helpful so far, don't forget to hit subscribe. It helps the channel grow, and it means you won't miss the next video that could save you a headache like this one. So what do you actually do with that time if you owe money but can't just write a check for the full amount? You've got real options and every one of them stops the bleeding. You can set up a payment plan where you pay the debt down in monthly amounts that actually fit your budget. Once that plan is in place, the levy threat goes away. If the debt is big enough that you'll genuinely never be able to pay it all, there's a process where the IRS will agree to settle for less than what's owed. And here's the one that matters most if you're living on a fixed income. If your income and resources are low enough that paying the debt would leave you unable to cover rent, food, and basic bills, the IRS can place your account in a status they call currently not collectible. While you're in that status, they stop everything. No levy, no seizure, nothing. For as long as your situation stays that tight, a lot of retirees living mostly on Social Security qualify for exactly this protection and simply never ask for it. Now here's the part I really want you to hear, because it's the part that should let you breathe a little easier. A lot of people picture the IRS draining their entire Social Security check down to zero. That's not how it works, and it's not allowed to work that way. Your Social Security retirement and survivor benefits cannot be wiped out completely to pay a tax debt. Through the program the IRS actually uses for this, the most they can take is 15% of your monthly benefit. Not all of it, 15%. Even in the absolute worst case, 85% of that check still lands in your account every single month, and it gets better from there. If your only income is supplemental security income, the program for people with very limited income and resources, that money is completely off the table. The IRS cannot touch it, not $1, period. Now here's a twist a lot of people don't realize. Veterans' disability benefits actually get their own dedicated protection, written directly into the federal tax code itself. The law specifically lists VA disability compensation as property the IRS is not allowed to levy. It's not just a general, the IRS is usually nice about its situation. It's spelled out in black and white. So if you're a veteran relying on that compensation, you're standing on some of the firmest legal ground there is. Let me paint a picture for you because the difference between two paths here is night and day. Picture two people who owe the exact same back taxes and they both get the exact same final notice on the exact same day. Person number one opens the envelope, reads the words about the levy and the right to a hearing, and inside those 30 days, picks up the phone. Maybe they set up a small payment plan they can actually afford. Maybe they explain they're living mostly on Social Security and can't pay right now. Either way, for that person, the levy never happens. Their account stays open, their check keeps arriving on time. The whole thing quietly moves onto a path they can manage. Person number two feels that exact same gut punch of fear, but instead of opening the letter, they shove it in a drawer and try to forget it exists. Sound familiar to anyone? The 30 days tick by, the levy goes through, the account gets frozen, and only then, in a full-blown panic, do they finally pick up the phone. Same debt, same letter, same income. The only difference between keeping their money and losing it was whether they opened the envelope while the window was still open. And that brings us to the one mistake that turns every single one of these protections into a disaster, and it's the same mistake every time. It's ignoring the letters. None of the bad stuff, the frozen account, the money getting pulled, happens to the person who opens their mail and responds. It happens to the person who sees an envelope from the IRS, feels that wave of dread, and can't bring themselves to look at it. But that's not even the biggest problem with hiding from it. Every protection we just talked about, the 30-day window, the hearing, the payment plans, the hardship status, every single one of them only works if you act before the deadline, and you cannot act on a deadline you never read. So here's exactly what to do, whether this is happening to you right now or it just shows up someday. Don't panic and don't hide from it. Open every notice the day it arrives and find the date printed on it. If you see the words "Final Notice of Intent to Levy," understand that your 30-day clock has already started and you need to move now, not next month. You don't have to handle this alone either. You can call the IRS directly to set up a payment plan, or for anything more complicated, bring in a tax professional, an enrolled agent, or a low-income taxpayer clinic, many of which help seniors completely free of charge. And if you're living mainly on Social Security, say so right away, because that fact is often exactly what unlocks the hardship protection. The IRS is far more willing to work with someone who shows up than to chase someone who's hiding. Your real power here isn't in fighting them, it's in answering them. So let's pull this together. Yes, the IRS has a power no ordinary creditor has, the ability to reach your account without ever setting foot in a courtroom. But that power is fenced in on every side by rules built to protect you. They have to warn you first. They have to give you 30 days. The bank has to wait 21 more. Your Social Security is mostly shielded. Your SSI is shielded completely. Veterans' disability benefits have their own dedicated wall around them. This system isn't built to leave a retiree with nothing. It's built to collect from the people who go quiet and to leave alone the people who respond and ask for the help that's already sitting there waiting for them. So before you go, do one kind thing. Think of somebody you love who'd rather stuff a scary envelope in a drawer than open it, someone carrying a quiet worry about money they might owe with no idea how many protections already stand between them and disaster. Send them this video. It costs you 2 minutes, and it could trade months of silent fear for the simple knowledge that they have rights, they have time, and most of their money is already protected. If you found this useful, make sure to subscribe and hit that notification bell so you don't miss the next one. And if you know someone who needs to hear this, go ahead and share it with them. Thanks for watching, and I'll see you in the next one.